We will start with inviting Mr. Aguilar for his presentation for this session. Mr. Aguilar, if you are ready, I'm pleased to give you the floor.
Thank you, and good morning, everybody. It's a real honor and a pleasure to be invited to this discussion, to this open discussion online, the way we used to for the last months. Regrettably so, it's difficult to have any other form of communication, but this is good enough to make it right, to make the points that I am committed to as chair of the Libe Committee, which is the lawmaking body in the European Parliament in the field of liberties, which is rights, fundamental rights, justice and home affairs. Rights, they are involved in this subject matter, for sure. Just to begin with, the rights which are encharted in the Charter of Fundamental Rights of the European Union. There is a Title 6 in the Charter of Fundamental Rights, justice, including the right to counsel, the right to the legal profession, the right to defense, the right to legal aid, which, by the way, have been developed by the European Parliament and the Libe Committee, particularly as a lawmaking body. We have actually delivered legislation on the matter. As I said, before coming to the European Parliament, I was Minister of Justice of the Spanish government, and I was very much related to the legal profession as instrumental to the realization of the rights which are involved in the field of justice. Justice was not always in the landscape of the competences of the European Union, but it is now, and it's there for good. Ever since the Lisbon Treaty entered into force with the Charter of Fundamental Rights, we have known for good that judicial matters, justice matters, and rights are of the essence for the European Union, which means that further developments in this area that once were kept for the competence or sovereignty of the member states are now to be tackled, to be put under the focus of the European institutions, of the European architecture, including the Commission taking initiative and the European Parliament in case as a lawmaking body. And this I am highlighting, this principle I am highlighting to understand that when we talk of justice, we do not talk only about the judicial system, about judiciaries. We also talk about the public service which realizes justice, which makes justice real, which delivers justice. There is an array of public services, administrative services, which put in contact citizens seeking for judicial remedy of their rights which are being violated and the judicial architecture. That is a very important area, space for digitalization. That means for improving the actual delivery of those public services by means of incorporating technologies, digital technologies, digitalization. And that is something that we have been discussing for the last at least 20, 25 years. I don't know a single member state of the European Union in which some sort of digitalization strategy has not been set forth, has not been put in place. Digitalization, let's face it, of justice is unavoidable, that for sure, including this public service through which fundamental rights are materialized, are concerned. But there are a number of considerations that are recurrent in the discussions here in the European Parliament and the Libe Committee that I would like to share with you, representatives of the legal profession, because we are here gathered by the Council of Bars and Law Societies, so with a focus on legal professions involved in the realization of justice. And these concerns that I would like to share with you, of course, have to do with rights of the European citizens which are involved. First of all, the right to equal justice, to fair and equal access to justice. That means that digitalization should benefit everyone, all European citizens, and not just a few, those who are not only digitally literate, but also who have actual access to technologies, to the white brand, or to the equips which are necessary for incorporating digitalization to its full potential. So caring that access to digital tools means actual access to law and to it's of the essence to understand what is at stake, both in social, territorial, and even generational terms. Because let's face it, the digital literacy among the younger generations is much wider than it is in the older generations. But older generations are also to be put on board, taken on board on this digitalization strategy. The second concern I would like to share with you is that the use of innovative technologies can certainly improve the efficiency of justice systems in every possible way, in all of the links of the chain, including the legal professions, solicitors, barristers, lawyers, administration of justice, and the actual duration of procedure can actually be rationalized, accelerated through a number of innovations which are already at hand: case management systems, electronic communications, video conferences. But in all of these regards, we have to take care that the rights of those who are subject to the justice system through the legal professions are to be fully protected, not diminished, not reshaped, not somehow reinvented or remade for the worse. They have to be enhanced by the incorporation of this digitalization in all of its potential, including the potential of artificial intelligence, which has been discussed by the European Parliament in this present minute, in this particular point of time. The third concern is that digital justice must not become unfair justice, by no means, which means that all of the rights which are there involved are to be not only preserved through the incorporation of digitalization, but in all of its possibilities enhanced, so that artificial intelligence in justice systems means no less predictable justice, means no less certain justice subject to legal certainty, especially in criminal matters, where both legal and ethic aspects of the discussion are now being handled, are now being tackled by the European Parliament, including facial recognition, evidence, electronic evidence, and all of those tools in judicial cooperation, cross-border judicial cooperation among the judiciaries of the member states, meaning that artificial intelligence and into judicial systems do need a comprehensive European approach, which makes sure that all of these innovative technologies are consistent with the European strategy and overviewed by European authorities. And that is the role that is to be played by the main institutions of the European architecture. The Council, when promoting initiative, the European Council, when promoting strategic initiatives, the Commission, when taking legislative initiatives, and the European Parliament, when involved on equal footing with the Council on ordinary legislative procedure in criminal matters and in judicial cooperation. Of course, preventing discrimination based on the management of sensitive data. We have carefully legislated on the protection of data of the citizens, privacy of the citizens, which, by the way, are also rights enshrined by the European Charter, not in the chapter devoted to justice, chapter 6, devoted to justice, article 47 to 50, but in articles 7 and 8, related to the dignity of every person on European soil, which means that privacy and confidentiality of data are also of the essence when incorporating all of these tools, e-evidence, facial recognition, and its transmission through automated processing or the incorporation of algorithms, the way we call or we used to refer to artificial intelligence. And a final observation is that the use of those tools based on artificial intelligence on the judicial system impose the respect of fundamental principles, which are always there, common to all systems, based on personal data processing in European Union and as a consequence in all of its member states. Transparency, impartiality, equity, assessment by external and independent experts, which makes it essential for that processing to be accessible and understandable for all. We have promoted in the Committee of Liberty, Justice and Security and Home Affairs, which I chair, we have promoted a tool which is already in place, actually carried out by the European Commission, the so-called Justice Scoreboard, which subjects to a scrutiny the performance of the judicial system when making an impact on the rights of the European citizens to access to justice in all of the member states of the European Union, according to a regular pattern every year, objective parameter, non-discriminatory, regarding efficiency and independence of the judiciary. In that regard, I think that when it comes to incorporating digitalization and new technological tools, we need also to make sure that Justice Scoreboard plays its part, plays its role, so that all of these strategies being set forth by the member states of the European Union do make sense in European terms, according to European law, are consistent with European values, Article 2, and with the Charters of Fundamental Rights, which is of the same value of the treaties. And I will make a final point as to the importance of having in mind that united in diversity is the motto of the European Union, which means that, yes, it is only clear that across the landscape of the 27 member states, the judicial systems are each and every one unique on their own. None is alike to any other. They are subject to common patterns and standards, and they must comply with the reassurances that the fundamental rights enshrined in the Charter do require. That's for sure. But judicial systems are each and every one unique in their own. They are not alike. The Irish judicial system does not resemble the Italian. The Spanish does not resemble the Slovenian. But in order to make sense when incorporating new technologies, we should also make sure that compatibility and interoperability are taken on board, so that when transferring data, when communicating digitalization strategies, we have actually something to share, which is common to all of us. with common parameters, because otherwise we will see troubles or decline of the goodwill, which will erode the very purpose of the strategy, as we have seen with some other tools that were so promising in the outset and now are facing practical problems in many ways. Let's think of the European arrest warrant. It really made sense back in 2002, but 20 years after, there are problems of its actual performance, of its actual delivery that have to be taken into account so that we draw the lessons. The point I'm making is that coordinated strategies to incorporate artificial intelligence and new technological tools, making them compatible across the member states of the European Union, despite the institutional differences of architecture of the judiciaries and the legal professions, because the organization of the legal professions is also very heterogeneous across the landscape of the European Union, and securing interoperability when it comes to sharing data while protecting those rights which are enshrined in the Charter, are, in the views of the European Parliament, of the committee which I chair, the main concerns that we have to bear in mind in order to be of use, adding value to this unavoidable horizon, which we are bound to face, which is full digitalization of justice and all of the rest of the services of the current contemporary states of the European Union, and as a consequence of the European Union itself. I thank you for your attention.